we're going to go back to hearing a bill, and before we start, I'd just like to make an announcement that we do have a Snapchat filter for WIDAC, and everyone should use it because the filter will be gone at 12 p.m., so you're running out of time, and it's very nice. So I would highly recommend everyone.
Thanks to Ava.
Yeah.
Yes.
All right. With that, is there anyone that would like to testify on Senate File 1386 that was not on the agenda? Okay. Then I call Senator Rolfe to present testimony about Senate File 1386 relating to children 10 years and over's right to counsel disclosure.
Thank you, Madam Chair. I'm just calling something up on my computer here, so I'm trying to get into the modern era. Unfortunately, in our proceedings, many times we stick to paper, and have not yet joined the modern era in terms of processing information in bills where we use computers. But thank you very much for having me. Today we're dealing with Senate File 1386, which is a bill designed to provide an additional layer of protection for children in juvenile courts. Except in cases involving habitual truancy, this bill would require that a child over the age of 10 be advised of their right to have an attorney present, appointed to represent them in the proceeding. Why is this important? In cases that involve abuse, child protection issues, or juvenile offenses, children need to know that they have the opportunity to be represented separately by counsel as opposed to a guardian who has counsel, a parent, or some other legal custodian. This case arose out of a situation with a young lady named McKenna Arenholtz, 12-year-old, who spoke about Minnesota's foster children's right to a lawyer being ignored. She didn't know she had a right to a lawyer. She didn't know that when her siblings were, she didn't know she had a say in where she was going to be placed during the child protection proceedings. So during child protection proceedings, a child may or may not be placed back in the home where abuse is taking place. So it's important for that child to have their rights represented. In her case, she and her siblings were forced to endure almost 3 years in and out of an abusive situation. What this law would do is require, simply stated, that when a child 10 years or older is brought into a child protection proceeding or other juvenile proceedings other than for habitual truancy, that they are to be advised of their right to an attorney. Not only that, but after they are advised of that right, they, and only they, can waive that right. A parent, a guardian, or other legal person with legal custody or legal control cannot waive that right. And this is important because the child is the one that has to make the decision. Now, some might ask, is a child 10 years old capable of making that decision? Well, the better question is to ask, let's find out. Let's let them make that decision rather than simply saying they don't have the right to make that decision. There are some additional protections that if the child desires to waive the right to counsel, they still are required to have met with an attorney and discussed their rights, even though that attorney doesn't necessarily represent them. They do have the opportunity to learn about those rights. So what we're doing is we're taking and protecting someone and protecting rights which they really already have. These rights to counsel, the right to have an attorney, already exists. The problem is most children 10 years old don't know that. And in fact, even children that are a little older than that don't know that. So the idea is let's make that information available so that they can make a decision rather than allowing them to suddenly end up in a situation that is detrimental to them. So the additional information is that I covered the idea that the child must have the opportunity to consult with a lawyer about her rights. The final issue is that most 10-year-olds don't have the money to pay for an attorney. And under our current statutes, a person who cannot afford an attorney will have one appointed for them by the court. So, with that, I would open it up for questions, if any of you have any questions.
Thank you for presenting, Ms. Medeiros.
Thank you, Madam Chair. I was wondering if you could highlight the differences between the bill we're looking at now and the companion text or the other version of this that has already been passed?
You mean in the House, in the other body, we call that the other body? I have not compared them, but it's my understanding that these are virtually identical in language. I haven't had an opportunity to look at the House version, but the idea, what will happen is so you understand the process. Obviously, the governor can only sign one bill. So if there are differences between the House and the Senate versions, what will happen is, first of all, one or the other body will be asked, do you accede to the language in the other bill? So if the House sends a bill over and it's fine, I see nothing wrong with it, I could simply say, we'll substitute the House bill for the Senate bill. Or we can say, no, we don't accede, and we ask the House if they will accede to our bill. If they say no, then the process goes to a conference committee. And the conference committee basically takes representatives from both parties in both houses and puts them in one room. And we then sit and hammer out the differences between the bills until we come to something that we can both agree on. Now, in my understanding, there is not a lot of controversy over this bill. The only question that has been raised is who is going to do represent the child, or who is going to be present in court in order to deal with that. And I have already discussed with the legal aid the ability of their office to be able to deal with this. And based on what they're seeing right now, they feel that that's something that they can deal with. So that would be the only question or the only controversy that might come up that I've been able to determine. Madam Chair.
Ms. Edgar?
Madam Chair, why did you choose 10 years old to be the age?
That's a good question. It was kind of looking at some other laws and other statutes and similar protection laws in other states that seems to find that 10 years old, in proceedings in domestic cases where there's a dissolution, usually a child 10 years old and above is permitted and in fact in many cases encouraged to bring forth testimony regarding the custodial parent and the actual time and where they would want to spend time with their parents. So that's kind of where that bar seems to fall.
Mr. Aaron?
Thank you, Madam Chair. I just have a couple questions from the students that were asked. I have asked, when will this bill start to be in effect?
Madam Chair, I will get the effective date. The effective date will be upon passage. So once the bill clears and is signed by the governor, it will be in immediate effect.
Awesome, thank you. And then I also have another question from Christy G. And they asked, if your identity remains with you and the government, how are other people capable of gaining it without them taking your ID, security card, and all of that?
I'm sorry, I'm having trouble hearing you.
If your identity remains with you and the government, how are other people capable of gaining it without them taking your ID, security card, and all of that?
Madam Chair, and I'm sorry I missed your name. I'm not exactly sure I follow your question. Are we talking about an ID card, or are we talking about your name and physical identity? I'm a little unsure as to the question.
I'm just reading it off here.
if this deals with identity theft or the fact of someone being able to take your identity, we're getting into a pretty deep rabbit hole that really was not the subject of this particular bill. I mean, if we want to go into identity protection and data privacy, I can certainly discuss that. Being a member of the Judiciary Committee, we deal with that. But if I would think you'd want to stay on topic, so.
Ms. Cormier?
Thank you, Madam Chair. I want to know what opposition you have received towards this bill?
Say,
The opposition you've received against the bill?
actually, there has been, no one has really spoken up against it. The only question, as I said, that was raised is the ability of the system to be able to provide the counsel to the children that are necessary. Otherwise, everyone has pretty much looked at this and said that this is something that we need to fix, which is very nice, that you don't have anybody objecting to what you're doing.
Mr. Lohmiller?
Thank you, Madam Chair. Pertaining to lines 2.3 and 2.6, will the information presented to the child also inform them of the possible risks of not having counsel or an attorney?
Madam Chair, and Weston, or Mr. Lohmiller. Counsel would be required to go through those issues if the child chooses to waive. In other words, the requirement is that the child speak with counsel, and the counsel would then outline the rights and also the risks involved in not being represented. As a former, I'd say former, I'm a recovering attorney. He spent about 30 years in private practice and had represented, prosecuted and represented defendants. And one of the things that as counsel you are charged with doing is making sure that the individual understands the rights that they have to an attorney and the risks that they entail by not availing themselves of that right. So yes, that would be discussed by counsel.
Ms. McComas-Wilson?
Thank you, Madam Chair. So, just as a point of clarification, you explicitly exempt cases pertaining to habitual truancy, and you've mentioned that this would apply directly, specifically to cases of custody. And what other, as I understood it, with domestic violence in custody, is that correct?
Madam Chair, yes, the application is broad. Basically, any juvenile proceeding would have this requirement, but mainly the focus is on child protection cases where the child is removed. This is where the case arose, was out of a child being removed from the home because of abuse, and then the Child Protection Agencies got involved, and in many cases, and rightly so, if it's safe to return the child, the object is to keep families together if we can. But unfortunately, in this case, the child was unable to get counsel and get people to speak up on her behalf. And in fact, she actually requested an attorney on 3 different occasions and was not given counsel, which when I found this out, I was just totally aghast, because the court in that case probably violated the law by not allowing that child to be represented. So we want to make sure that children in cases involving court proceedings are represented if they so desire.
So in what other cases would this pertain to? You said it was a broad application, but I'm just wondering for context what other cases.
Well, in a case of juvenile theft, for example, if a juvenile were arrested for theft, they would have the right to be told that they have the right to counsel. Now, usually in criminal cases of criminal activity, that takes place just as a matter of course. But the main hole and the main place that we found a problem in the statutes was that in cases of child protection specifically, that's where this arose. But this would also apply to cases, custody cases, and similar situations.
Ms. Gard?
So, vote to receive, thank you, Madam Chair. Vote to receive counsel and to waive waive a counsel. It says that the court is entirely responsible for determining whether the child is making the decision voluntarily and intelligently. But what are the protections? And it also states that the court cannot permit the child's parent to waive a counsel. But then what are the protections for a child that may not be able to make an intelligent decision if they are showing that they want to either waive or not waive the counsel? And then also if they're being exploited by counsel, how can they go about that?
Madam Chair, let me break that into a couple of segments. Let's start with the protection. The idea is that the child, no matter what, will talk to an attorney. Whether it's their appointed counsel or an attorney that the court provides for them to speak to regarding waiver of their rights, they will, the intention of the law is to guarantee that they have an opportunity to learn about the rights that they have to be represented in a proceeding. I'm not sure what you meant by influence or abuse by counsel. I'm not sure what to address on that.
Not necessarily abuse, but just any type of exploitation of their rights that they might be unaware of, but their parents might know about, but their parents cannot go to the court and say anything on behalf of that because it's the child's responsibility.
Well, first of all, in terms of an exploitation by counsel, if that's taking place, first of all, I would hope that the court would observe that, and if it doesn't, and the parents certainly are not without the right to come into court and say, I see something here that I don't think is right. And at that point, the judge should ask questions or examine the child to make sure that the child is being properly represented. As an attorney, personally, it would be reprehensible to take advantage, especially of a 10 or 11-year-old child. I mean, even economically or in some other manner than some abusive situation. So I'm not exactly sure how to address that question other than I believe that there are adequate, or at least I would hope there are adequate protections built in that somehow that information would reach the court and the judge would then have the ability to say, wait a minute, there's something that just doesn't pass the nose test here, and go forward. I hope that answers your question.
Okay, I'm going to close discussion and motion that Senate File 1386 be recommended to pass. Again, I'll call on everyone for a roll call to vote. Say yes if you would like the bill to pass, and no if you would not like the bill to pass. Munira Alimir. Alyssa DeGrand.
Yes.
Weston Lomiller.
Yes.
Angelo Perez.
Yes.
Catherine McComas-Bussey.
Yes.
Shreya Ram, yes. Fatima Manawa.
Yes.
Elena Medeiros.
Yes.
Ava Clems.
Yes.
Suhani Garg.
Yes.
Brian Forsman.
Yes.
Marvin Lopez Rosas.
Yes.
Brandon Walensky.
Yes.
Jacob Just.
Yes.
Robert Johnson. Noah Aaron.
Yes.
Bailey Norris.
Yes.
Hannah Erickson.
Yes.
Rhea Edberg.
Yes.
Addie Ness.
Yes.
Raina Mayer.
Yes.
Mimi Lee.
Yes.
And Harita Dugirala.
Yes.
With unanimous support and 23 votes yes, the motion does pass.
Thank you, members and Madam Chair.